So, in general, in the market, you as a consumer, you want to buy a product that maximize your benefit. Okay, whereas seller wants to sell a product maximizing his profit, right? So competition is all about this. Okay, like you as a consumer want to maximize your profit, whereas seller wants you as a consumer want to maximize your benefit, whereas seller wants to maximize their profit. Okay, so for this reason only, the act is actually enacted, and just before we go into the competition law, we'll just see what was there before. Okay, so initially there was something called MRTP Act, that is Monopolies Restrictive Trade Practices Act 1969. So this was the act which was there before this Competition Act. Now this act is repealed, and then the Competition Act came into force. The um, concept of Monopolies Act can be divided into MRTP Act can be divided into three things. One is MTP, that is monopolistic trade practice. Then is RTP, restrictive trade practice. Then is UTP, that is unfair trade practice. Right. So, these are the three anchors through which MRTP Act has dealt with, and for this they have actually had something called a MRTP Commission. Okay, which was actually like a regulatory body to regulate this monopolies and restrictive trade practices which are there in the market. So the word monopoly, like people who would have read economics would have heard this. A monopoly is like you are the only person in the market, right? So railways is one of the monopoly in India, where which only government operates the railway. Recently, that has also been privatized, but that is how you have to understand, like when which there is only one producer, or like say though the railways are privatized, there is the dominant person is still the government. So there is only one dominant entity. Then restrictive trade practice, in this you can find actually a lot of types of restrictive trade practices which are in practice in the market. When you go to assume you are going to, I think you would have gone, you heard of this KFC, right? So if you go to KFC, or if you go to Domino's, like to get pizza, you'll always find that they will serve only one particular range of cool drinks, right? Like Domino's will only serve you Coke or Coke products. Like whereas if you go to Pizza Hut, they will serve you Pepsi or Pepsi products. So the reason is that kind of restrictive trade practices they have actually opted, but it is not prohibited under law, because if you don't want to, if you want you're going to Domino's, but if you want to drink Pepsi, you always have an option to go to some other place and you can buy and you can drink. So that is the reason why all these practices are not curbed. But these are then examples of restrictive trade practice. Okay, unfair trade practice. There is three concepts. There is forestalling, pushing up prices of the product by buying up supplies in the market. Like you can think of a recent situation in which the normal mask which used to be available in this medical store, it used to cost 1 rupee earlier. Now the rates are like 50 rupees for the same mask. Like how come this kind of things have raised? So whether people have actually created artificial scarcity in the market, or what is the scene which has happened? So that is kind of practices can be a unfair trade practice, or unfair trade practice are also called market offenses. Okay, so to enable the why Competition Act came into place was MRTP Act was not successful in curbing monopolies, but then they thought we should promote fair and healthy competition in the market. Okay, doesn't matter whether there is a monopoly, but we should have a fair and healthy competition in the market, so that there is a consumer well-being, and markets function effectively with adequate and affordable choices. So whenever you think of this concept of choice, you can go to some 20 years earlier. Like in Indian car market, you would have only seen Marutis and Ambassadors, and like few other cars like Fiat and all. So what does this mean is the consumer's choice is limited then, right? So that time a consumer had a very less choice. So over the period, like now, if you see any new car which is launched globally is there available in India, and the price has also become competitive because every player wants to sell their product. So they have tried to like adjust the prices. So literally, you have Hyundai competing with Maruti like anything now, right? So because of the like demand and supply, prices has also been regulated. So this is the aim of Competition Act. Competition Act, the whole aim is to regulate the prices so that ultimately the public or consumer is benefited. Okay, yeah, and see, you would have heard of this term agreement in your contract act, and you would have heard of this term consumer when you read about your when you read in Consumer Protection Act. But what is the difference between an agreement under Contract Act and a consumer under Consumer Protection Act when it comes to a Competition Act is that Competition Act is very wide enough that an agreement to include a kind of understanding also. Okay, any kind of understanding can also be an agreement. Understanding like need not be in writing also, right? Same way, like when you cover under the Consumer Protection Act, like only those who consume products for their own or personal use are only treated as consumer under Consumer Protection Act, whereas under Competition Act, that is not so the case. Okay, so that basically means anybody who is purchasing the products for their own use or for the purpose of resale or any other commercial purpose can also be treated as a consumer. Okay, so what kind of agreement or understanding is covered? So we have to see what is the course of conduct. Okay, course of conduct. Just try to understand the situation. Like suddenly, there can be a simultaneous increase in the prices of a product. Okay, like that could have happened because of some kind of communication which happens between the parties. Okay, and each party led to expect that others will act in a certain way. Each dealer acts and behaves in such a way with expectation that other will also follow in a similar way. If if this kind of expectation happens, if this kind of activity happens, then only we call that as an understanding. So mask prices have gone up. ஓகே. எல்லா மாஸ்க் ப்ரொடியூசர்ஸும் சேர்ந்து நம்ம வந்து ஃபர்ஸ்ட்டு ₹10 வைக்கலாம், ₹20 வைக்கலாம். நவ் வில் செல் த மாஸ்க் அட் ₹40, ₹50. If they plan it in such a way and they keep increasing the prices, that's what we call as a course of conduct by which the with a common understanding between all the parties, the prices have gone up. Okay. The parties should recognize the implication and there should be a mutuality. Okay. As a result of this communication or conduct or behavior, the parties adopt the course of conduct. So in the mari ella situations, if it is satisfied, that's when we call that as a agreement or understanding under the Competition Act. Okay. So it's not the strict agreement what you see in the contract law, which is in writing between the parties, enforceable by law. We need not have to satisfy all those conditions. It is only we have to see whether it is a common understanding by which the parties have acted in concert together. So as long as that is there, that is an agreement under this. So, simply put, what you have to remember out of this discussion on agreement is agreement includes any arrangement or understanding or concerted action, whether or not is formal or in writing, whether or not is enforceable by legal proceedings. So, this is the takeaway you have to remember. So, if they like in Competition Act, first thing you have to check is whether it is an agreement or not. So for that, you have to check whether it includes any kind of arrangement or understanding or concerted action. It need not be in formal or writing. It need not be enforceable by law also, right? Coming to the consumer. So consumer means any person who buys goods or service, or user of goods or service, or beneficiary. Okay, that means either you can buy and use it for your own self, or you can buy for commercial purposes or for resale also. So the definition is wide enough. And now you have to see like who is this person, right? So person includes is a, so whenever you see the word includes, is an inclusive definition. So person includes like anybody individual that you have, like it is like wide enough to include like any artificial juridical persons. And goods, like immediately goods means you have to remember like goods is defined under Sale of Goods Act. So there it says goods can be it can be a movable property, whether it is manufactured or processed product. It includes also debentures and shares after allotment, or even goods which are imported into India for supplies or distribution in India. Service means service of any description made available to potential users. Education is a service. Okay, service also includes services of commercial nature or business purpose. So service is very wide, like to even to include like activities like education or commercial nature or business purposes. Okay, so now we'll go into the definition of the term enterprise. The enterprise is a enterprise means like a person or department of government. So even government departments are also included as part of definition of enterprise. So which does any kind of activity like this: production, storage, supply, distribution, or control of articles or goods or services, or also makes any kind of investments, kind of like into shares, debentures, or any other securities. So all these things, but it specifically excludes like if enterprise doing any sovereign functions, or dealing with atomic energy, currency, or defense in space, or any kind of thing which is in public interest. See, remember, when it comes to government, government can do a commercial activity also, and government can do a sovereign activity also. If government is running Air India, right? See, Air India is a like a flight which is running commercial operations, because there are so many other flight operators like your SpiceJet, Indigo. There's so many other flights of flight operators, and Air India is competing with all of those. So that is not a, sovereign function, but it is a commercial function. Whereas railway is a sovereign function, because there predominantly it's only government which is operating, right? So this does not include like if government is doing any kind of sovereign functions, but only it includes like commercial activities of the government or a department of government. Okay, now coming to what is the Competition Act does. Okay, see, till now whatever we have discussed, three things are very important. What is an agreement? Okay, what we have discussed. And second, like who can be included as consumer into Competition Act. Third, what types of enterprises are covered. Okay, these three are very important from the exam point of view. Before that, like it's just a general things on how the monopolies MRTP Act was there and how it became Competition Act. Now let's focus. What is the Competition Act tries to do? So as we discussed, immediately when you think of Competition Act, you have to think of fair and healthy competition. So what it tries to take away is like any kind of like negative aspects of competition. It tries to take it away, for which and how it does by a regulator called CCI, which is a Competition Commission of India. Like CCI is like a is a has a features of a body corporate, and it's a regulator like SEBI. Okay, so like you would have studied your securities law also. There you will find Competition Commission of India. Similar to that, CCI is also a regulator. Okay. See, எல்லாத்துலேயும் இந்த composition based ஒரு question இருக்கும். So basically CCI will have a chairperson, will be appointed for every 5 years once, and it will have 2 to 6 other members who are below 65 years of age on whole time basis. அண்ட் எல்லா காம்போசிஷன்லேயும் இதே மாதிரி தான் இருக்கும். சேர்பர்சன் இருப்பாங்க, அதர் மெம்பர்ஸ் இருப்பாங்க. தே ஷுட் பி ஹேவிங் எபிலிட்டி, இன்டெகிரிட்டி அண்ட் ஸ்டாண்டிங். And they may possess special knowledge with respect to competition, and they should have at least 15 years of experience in the relevant field or on the competition matters which CCI deems it essential. So these are the composition of Competition Commission of India. Okay. Then it will have a chairperson and members, like whosoever has been appointed can be removed only after an inquiry by the Supreme Court. Okay, because they are a part of regulators, they can be removed only after an inquiry, and only in cases like if you could remember, if you have read Companies Act, if a director is adjudged as insolvent, or if they are convicted of any offense or involving moral turpitude, or if he has abused the position or in public interest. So in the many cases mattuna, that too only after conducting an inquiry a person, chairperson or member can be removed. Similarly, if they are resigning and they are going out of CCI, they cannot join any other private like enterprise who were on whom the case was running before CCI, but they can join only after 2 years. This is just to prevent they don't go and support them. So only after 2 years they can join any kind of take up any kind of job in a private enterprise. This is like a restriction period. Only they can only serve take up private employment only after 2 years of holding the of ceasing to hold the CC office. Okay. See, எதுவும் டவுட் இருக்கா இது வரைக்கும்? If you want to talk, you can unmute and talk, or if you want to even put a message in the chat also, you can put. எதுவும் இருந்தால் you can ask me then and there also. So if it's not there, I can move ahead. Yeah. சொல்றது புரியுதுல்ல? Hope you are able to follow me. Like இதே ஸ்டைலில் போகலாம்ல? You're able to understand the English also, right? Okay. So now there are, apart from the chairperson and the other members, there is also a person called Director General. See, they can ask you a 5 mark question on this. Okay. See, anytime a CCA finds that there is a violation of the provisions of the Competition Act, it can refer investigation to the Director General. Okay, so Director General can carry out investigation under Competition Act to find out whether there is violation or not. And they will have the powers of inspector under the Companies Act for carrying out that investigation. So remember, they will prepare an investigation and they submit an investigation report to CCI. But CCI is not bound by the report submitted by the Competition Commission. CCI is not bound by the report submitted by Director General. Okay, that's what they may or may not subscribe to the recommendation of Director General. Okay. Now, see, like if you could recall, if you read your general law, you could have known of this term preamble. Preamble is nothing but what is the objective of the act as given by the initial things. You will find the first part of the act itself, you will find preamble of the act. So they are basically the objectives, and here that is also the duties of Competition Commission of India. So this is very important. Whether if you are not able to answer any question under this, you can write about this. Whether it prevents adverse effect on competition, whether there is promoting and sustenance of competition, whether it is acting in the interest of consumers, or whether there's a freedom of trade which is there. So this is what you can write. This is the basic uh, preamble or presumption under which the whole act operates. This is very, very, very important. Okay. So also what you have to remember is CCI also has an extraterritorial reach. If whatever happens, like if an act which happens outside India but has a impact in India, right? An act takes place outside India but has a impact in India. It has a effect in India. As long as this is there, CCI has extraterritorial jurisdiction also. Okay. So see, you need not remember all the sections, but very few sections you can remember. Out of that, the important ones are section 345, okay, which we'll discuss little later, and other is on the inquiry by Competition Commission, which is dealt under section 19 and 20. Okay, both are interconnected. Okay, we'll see this little later. Okay, so what you have to remember out of here is CCI can act on suo moto basis or on receipt of any information. That means you and I can also give information to CCI if there is any kind of malpractice happens, or if government can also seek a opinion of Competition Commission of India. So three things: suo moto, that is on its own motion, or on receipt of any information or notice from any person or any consumer or association, or on reference by, see, you see the usage of word own motion, receipt of information, reference of government. This is very important. You should remember own motion, receipt of information, reference by government. Okay, this is again you have to remember. Who can appear before CCI? See, unlike a court, CCI is a modern day regulator. Apart from the complainant, defendant, say, apart from them, it can also be represented by a CA or a CS or a like a cost accountant or any legal practitioner like advocates, right? Just a second, just go through this. So, what have you read here? What are the powers of Competition Commission of India, and or what are the powers of Director General, or what are the powers of any regulator or authority or tribunal? So tomorrow they ask you a question on Companies Act. What are the powers of National Companies Law Tribunal? You can write the same thing what we are going to discuss here. Even if they ask you under your foreign exchange laws, what are the powers of RBI? You can write the same thing. So any kind of regulator, any kind of authority, any kind of tribunal, what are the powers of SEBI? You can write this. Okay, so these are the general powers which are available to any regulator or a authority or a tribunal, right? So like you have to, if you're writing about SEBI, just replace the word CCI with SEBI, then that's it. Okay, so just remember, any of this CCI, Competition Commission of India, shall not be bound by the procedure laid down in Civil Procedure Code. Okay, but it shall be guided by principles of natural justice. So, what do you mean by principles of natural justice? Principles of natural justice are nothing but like you should give a opportunity of being heard. Okay, opportunity of being heard before passing a order. Okay, that is what the principle of natural justice is. சிம்பிளா சொல்லணும்னா உங்க மேல ஒரு கேஸோ இல்ல ஏதாச்சும் இதோ போடுறதுக்கு முன்னாடி உங்களை பேச விடணும். அதுதான் ஆப்பர்ச்சுனிட்டி ஆஃப் பீயிங் ஹர்ட். நீங்க சொல்றத கேட்டுட்டு தென் தே கேன் ஆக்சுவலி பாஸ் அ like order or anything against you. Okay, so CCI can regulate its own procedure, like where it has to do sittings. Sittings is nothing but where CCI will hear a case and how long it will hear a case and what will be the timings for inquiry. All those things. See, you may see the word inquiry and enquiry used interchangeably, IN or EN. You can write it in both the way. Just the difference of British and American English. Both the things are fine. Okay. So see, remember, CCI shall not be bound by CPC, that is Civil Procedure Code, but it will be deemed as civil court. Okay, and proceedings before CCI are deemed to be judicial proceedings. Okay, CCI is deemed to be civil court, and proceedings are deemed to be judicial proceedings, and it has the following powers of civil court while trying a suit. Okay, just read this as many times as possible. As I told you, this is very important. I think yeah, I can see a question on adverse effects of competition. See, that we'll discuss when we go little later. I have reserved that discussion for little later because that is one of the crucial thing under the Competition Act. We'll just discuss it little later. Okay. Yeah. So continuing this, powers of Competition Commission, that is nothing but they have a powers of civil court. And what are the powers of civil court? First, to call for any person. Okay, that's what we say, summoning. Like any person and கோர்ட்டில் பார்த்துருப்பீங்கல்ல படத்தில் கூட்டு வந்து இந்த லைக் நான் சொல்வதெல்லாம் உண்மை அப்படின்னு சொல்லுவாங்கல்ல, that is what is called calling a person and examining them on oath. Then like you can ask for evidences, that is what discovery and production of documents. First கூப்பிடுறது, then calling for evidence and receiving an evidence on affidavit. Affidavitல we have to give a declaration that whatever is given is correct. That is what is an affidavit. Then like if they are not able to come in person, கூப்பிட்டு வர முடியல, or if they are not able to submit any document as an evidence, in that case they can examine the witness or documents, issue commission for examining the witness or documents. Okay. So see, this is very 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 important, so read it as many times as possible. Okay, what are the powers of this? Like, if they ask you any question which you don't know the answer, you can straight away start writing what are the objectives of Competition Act and what are the powers of Competition Commission. Mostly, it will be right. Okay. Then requisition of any public record. Okay. See, remember, like you cannot go to a when CCI wants some kind of a record or document, they cannot ask the bankers to provide a bank account statement. Okay, because they are not supposed to provide that. That is something which they have a privilege given under the Indian Evidence Act, because it is something privileged information, right? Then dismissing an application in default or deciding it ex parte. Ex parte means without the presence of other party. That is, like by hearing only one side of it, they can pass an order. Okay, or any other prescribed matter. So this is a standard point which you can add in anything where you don't remember the points. Okay, so that's what I told you in this note also. Like whenever you are answering any kind of question, like what are the procedure to be followed on inquiry by CCI with regard to agreements, dominance, or combination, you can always write that these are the things, right? So what is the takeaway from here? You have to remember, like CCI is deemed to be a civil court, and proceedings are deemed to be civil proceedings. However, Civil Procedure Code will not apply. Instead, they will be governed by the principles of natural justice, and they have all the powers of civil court. So the powers of civil court are these pointers what we have discussed. So this is clear, right? So as I told you, this is very 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 important from the exam point of view. Okay. Done. So what if you don't see what we are discussing now? It's all connected with orders passed by CCI, Competition Commission of India. Okay. So if you don't comply with the orders passed by Competition Commission of India or the directions given, see, be careful of usage of the words orders of CCI, whereas directions of Director General. So Director General gives directions, CCI gives orders. Okay, but be very careful when you're writing all this. So if you don't comply. See, there is an appellate authority called NCLAT, like we should have read in Companies Act also. They are the appellate authority here also. So you can ask them, you can put an application before them for recovery of compensation if they violate the orders of CCI. Or in case of Director General, there can be a penalty of 1 lakh per day, subject to a maximum of 1 crore, as may be determined by the Competition Commission. See, remember this, they can ask you as a separate question also. In case of a company, who will be liable? See, company itself will be liable, plus the director, manager, secretary, or officer shall be liable for contravention of any of the provisions of this act or orders passed by CCA or Director General. This is a important question by itself. Okay, so assume CCA has passed an orders. Can it rectify its orders? The substantive part of the orders cannot be rectified, but if there is some mistake, it can always be rectified on its own motion or parties யாரோ வந்து இந்த இதில் இந்த சின்ன கிளரிக்கல் மிஸ்டேக் இருக்குது அப்படின்னு சொன்னாங்கன்னா they can always rectify. Okay, in your material there is a printing mistake that they have used the word ratification of orders. Remember, that's not ratification, it's rectification of orders. Okay, then comes execution of orders. Okay, execution of orders, that is whenever they impose any penalty, how they execute. They have the like here the person on whom penalty is imposed are deemed to be an assessee under the Income Tax Act. So they are supposed to pay how they are supposed to pay income tax, like that they are supposed to pay the penalty. That's why we call any person on whom penalty is imposed are deemed to be a assessee under the Income Tax Act for recovering the monetary penalty. Yeah. Yeah. See, apart from this, there is a power to make rules. See, here again, just carefully observe the term central government's power to make rules, whereas CCI power to make regulation. So, just see these examples that these are the rules which are made by Competition Commission. That means you should remember these are rules which are made by made by central government, whereas these are regulations, right? These regulations are issued by Competition Commission of India. You're able to understand the difference. So, who is the central government issues rules under the Competition Act, whereas Competition Commission being a regulator, see, regulator issues regulation. Okay, central government issues rules. Try to understand the difference. So, for these kind of things, like whenever they make a rule or regulation, it has to be laid before each house of the parliament, that is your Lok Sabha and Rajya Sabha, for 30 days. And if there is any comments, it will be modified accordingly, and then it will take effect once it is published in the official gazette. Okay, yeah. So then comes the appellate authority. See, earlier it is called Competition Appellate Tribunal. Now they have made it as NCLAT because Competition Appellate Tribunal was not never constituted. So they gave the powers to the under Companies Act. We have this NCLAT. It will function as a Competition Appellate Tribunal also to hear appeals against the orders passed by CCI. Okay, and to recover any kind of compensation under the Competition Act, NCLAT will act as the appellate authority. See, here you have to remember the timelines. Appeal timeline, which is like appeal has to be filed within 60 days, and then of the order of CCI, and like CCI, NCLAT, that is the appellate authority, shall take endeavor to dispose the appeal within 6 months, right? uh, After giving an opportunity of being heard. This is nothing but what we discussed, that principles of natural justice has to be followed. right? And if you're still not happy with the orders passed by NCLAT, within further period of 60 days of that order, you can always approach the highest court of land. Remember, here there is in the high court, there's no involvement of high court. Straight away from this, you will go to the Supreme Court. Okay. So finance, accounts, and audit is general. Like finance is the fund, so they create something called a competition fund for spend like it will have a credits of government grants and debits as expenses. Like accounts are prepared in consultation with the CNAG, Comptroller of Auditor General of India, and they do the audit also at regular intervals. And the whatever they do, it will be reported to central government and laid before House of the Parliament. Same way, annual returns on all these matters on competition issues are also like laid before Houses of the Parliament. See, this also they can ask us a like a 5 mark question kind of, right? Okay. So with this, the general concepts are discussed. Now we are going to the essential provisions that is called the Pillars of Competition Act, and now only we are actually going into the act. Okay. See, I want you to actually concentrate fully, because if you concentrate, it's very, 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 very easy. So, like, just feel fresh and try to have as much of concentration as possible. Because if they ask you any direct question or case law based question, everything like how to analyze and how to come to a conclusion is what we are going to discuss now. So, can we start already? Just skim through what is there in your screen, and just give you a minute. Just skim through what is there in the screen, and like create your attention towards it and focus here. So read it. See now, see here we are dealing about four sections. Section 3, right? Section 4, Section 5, Section 49. See, in exams, remembering sections are not important, but in Competition Act, like there are very few sections to be remembered, out of which these are the important sections. Section 3, Section 4, Section 5. So we are dealing about, see, see carefully observe the word. We are prohibition here, regulation here, right? So what we are discussing is anti-competitive agreements, abuse of dominance, and combinations in the nature of mergers, amalgamation, acquisition, and takeovers. Okay, mergers, amalgamation is one bit, acquisition and takeover is other bit. Okay. Before we go into this, let me. This is a separate 5 mark question by itself. What are the competition? What do you mean by competition advocacy? Is nothing but the Competition Commission of India will give its opinion to government, like whenever government seeks its opinion on possible effects of any kind of policy. Government is going to come up with a new policy. They will first check with the commission whether there is any possible impact of this policy which it have on competition issues. Remember, CCA's opinion, whatever it gives, is not binding on the government, but generally government seeks its opinion. Then this CCA creates awareness. See, yesterday there was a program organized by MCX by ICSI Madurai chapter. that is to create awareness about the multi commodity exchange in the markets. Same way, CCA also does this kind of awareness programs, and it also imparts training on competition issues. See, this may sound very simple, but this is a repeated 5 mark question in exam. So, just if you remember this, you can actually get 5 marks. Competition advocacy. Try if you can remember the section also. Competition advocacy is dealt under section 49. So, whenever central government seeks its opinion of CCA on any policy matters, it has to give its opinion within 60 days, though government is not bound by its opinion. Plus it creates like awareness on competition issues, and it also gives training on competition issues to common public, right? So now we are going to the major thing. See, as I told you, under MRTP Act there were three things: monopolies, restrictive trade practice, and then there is a that is classified into three. One is a monopolist trade practice, then there is a restrictive trade practice, then there is a unfair trade practice. So how they have different, see, remember, there is no concept of regulation of combinations under MRTP had only monopolist, restrictive trade practice, monopolist trade practice, restrictive trade practice, and unfair trade practice. Now this is how it is realigned. So restrictive trade practice and unfair trade practice is brought under anti-competitive agreements, whereas monopolistic trade practice is brought under abuse of dominance. Clear? Now, if any kind of this anti-competitive agreement or abuse of dominance or combination creates adverse appreciable effect on competition, then such agreement or dominance or combination shall be void. Okay, just this is very, very, very important. So before you understand the meaning, try to understand the concept. Okay, we'll understand the meaning of when it creates adverse appreciable effect later. For when it creates adverse appreciable effect for anti-competitive agreement, for dominance, for combination. But as of now, what you have to remember is, if any anti-competitive agreement, if any, so if they ask you a question on anti-competitive agreement, you have to only write, if anti-competitive agreement creates adverse effect on competition, then such agreement shall be void. If they ask you a question on abuse of dominance, you have to say, like, if there is a dominance and if there is an abuse of dominance, then that shall be void. Same way, if there is a combination which creates adverse appreciable effect on competition, then such combination shall be void. Right? Okay, we'll discuss this concept one by one. I think this is clear, right? This is the whole essence of the Competition Act, or the anchors or the pillars of Competition Act. So now we are starting on this anti-competitive agreements. So any kind of a agreement by any enterprise or persons in respect of production, storage, or of anything of goods or material or services which is likely to cause adverse appreciable effect on competition within India shall be void. See, void is a nullity in law, right? So agreement, if it creates adverse appreciable effect on competition within India, shall be void. Okay. First, you should understand what are the types of agreements. Okay, there can be a horizontal agreement, there can be a vertical agreement. So horizontal agreement is between like two players. Like, say for example, Maruti is a car manufacturer, like Honda is a car manufacturer. Okay, so if these manufacturers, you can think of Mahindra as a car manufacturer and Ford as a car manufacturer have an agreement. Same way, Maruti as a car manufacturer and Toyota as a car manufacturer has an agreement. So these kind of an agreement are called horizontal agreements. That is between two or more sellers or two or more buyers. Okay, they are in the same field. Maruti and Toyota is in the same field. Ford and Mahindra is in the same field. So when they enter into agreement, okay, they are called horizontal agreement. This is more like RTP under MRTP. And vertical agreements are like, say, Maruti Cars has this showroom called Nexa, right? So Nexa showrooms, if Maruti enter into a contract with its one level below, that is the wholesaler or retailer. That is what we call as a vertical agreement. So horizontal agreement is the horizontal way, vertical agreement is vertical way. So in general, horizontal agreements are very serious in nature and are deemed to be anti-competitive by rule of law. Okay, vertical agreements are anti-competitive only if it affects the competition. That is, we have to give reasons how it is affecting the competition. Okay, just remember this, very important. Like if they give you any kind of agreements, first you have to check whether it's an agreement or not. Agreement, we have seen the definition, it's an understanding, concerted action. So you have to check that, and then we have to check whether it's a horizontal agreement. If it's a horizontal agreement, it is deemed to be anti-competitive. The other party has to prove that no, it is not anti-competitive. That is defendant has to prove. Okay. Whereas vertical agreements, only if it affects the competition, it becomes anti-competitive. Okay. So what are all types of agreements that can be a horizontal agreement? Um, like that is like agreements determining trade prices or limits or controls production, like or sharing the market area. We will just discuss this in detail. As of now, remember these kind of agreements can be a horizontal agreement. These are examples. Like bid rigging and collusive bidding and cartels. These are very important questions which are repeatedly asked in the exam. We'll discuss this in the next slide. Apart from this, like any kind of agreements which are related to different stages or levels of production or different stages or levels of supply chain, production chain or supply chain are vertical agreements. So this can be tie-in arrangement, exclusive supply or distribution agreement, refusal to deal, resale price maintenance. These are examples of vertical agreements that we'll discuss now. So you are clear till now, right? One more thing, the difference between MRTP and Competition Act is under MRTP only the restrictive clauses in the agreement stands void, whereas under the Competition Act the whole agreement stands void if it creates adverse appreciable effect on competition. What is adverse appreciable effect? We'll discuss it a little later. Okay. Now we'll see what are not anti-competitive agreement. See, if assume somebody, some company finds a medicine for corona, okay, the vaccine or whatever. So they will first protect the rights by filing a patent, right? So when they file a patent, anybody else using the medicine has to give royalty to them. Only then they can produce that medicine. See, one company will find, all other company will pay royalty, right? So the company which has found the medicine is given a privilege of exclusively taking royalty from anyone and everyone. See, this kind of practice is not anti-competitive practice because these are agreements which are permitted under intellectual property law. So Patents Act allows this, right? Though like whole world has to pay royalty to the person. Okay, but it is allowed under patents law. That is why these are not anti-competitive agreement. Same way, if like any person is given an exclusive right to export, say the same company which owns the vaccination is given a right to export that, that is exclusively, that is also not a anti-competitive agreement. So this is again a separate question. 3 marks they can ask you in exam. What are not anti-competitive agreements? Okay, now as I told you, like horizontal agreements are deemed to be anti-competitive in nature, and now we are seeing what are the types of horizontal agreement. Each of these pointers are separate 5 mark question. This is a separate 5 mark question. This is a separate 5 mark question. Collusive bidding or bid rigging. Okay, so any kind of, say, I try to give examples then and there. So just try to relate that with, so it will be easy. Any agreement between enterprise or persons engaged in identical or similar production, like say Airtel and Geo, both offers SIM cards and both offers like phone services and the data services, right? So if this agreement uh, creates adverse appreciable effect on competition. Okay, for like say there is some kind of bidding happens, spectrum allocation happens by try, and they have some kind of a arrangement or an agreement. Okay, and if that well bidding, so if that creates or manipulates the bidding process, then that's what we call as a bid rigging. Yeah. Airtel and Jio, when allocating spectrum, if they do some kind of a concerted action, which creates adverse appreciable effect on competition for bids or manipulates the bidding process. That's what we call as bid rigging. Cartel. See, this is actually a live case when which association of cement producers like Ramco, Dalmia, Ultratech, so many others also have actually so they are all cement producers association. So what they did was they controlled the cement production, by which artificial scarcity was created and cement prices have gone up for all buyers in India. So this is what we call as a cartel. Cartel is kind of act together by which they limit or control the production, thus increasing the prices of the product. So in the cartel members, that is the cement producers, can be for this case they were actually penalized for three times the profits made out of cartel. Okay, or 10% of the turnover for each year, whichever is higher. I see here in competition commission there is something called a lesser penalty clause. Like say in this case, Ultratech Cement goes and tells competition, yes, we are doing this cartel. Then it's like the போட்டு கொடுக்குறதுன்னு சொல்லுவோம்ல அந்த மாதிரி பண்ணா there will be a lesser penalty to that person. That is person whosoever makes true and vital disclosure of this to Competition Commission of India, they will get a lesser penalty compared to others. Okay. So these are important 5 mark question. So you're clear with bid rigging and cartel. So how to answer a question apart from writing this? If they ask you bid rigging, first you should explain this concept. Then you should say bid rigging is an example of horizontal agreement. Okay, horizontal agreements like what we also read about horizontal agreements. Horizontal agreements are deemed to be anti-competitive, right? Horizontal agreements are deemed to be anti-competitive. Okay, and if any enterprise enter into such horizontal agreement in respect to like any of this, which likely to cause adverse appreciable effect on competition, it is void. That's it. Okay, so it's very, very, very easy. You have to only remember this concept. Whatever question they ask, see, even if you don't know what is cartel, as long as you know cartel is a horizontal agreement, and it falls under anti-competitive agreements. So you can say cartel is a horizontal agreement which is deemed to be anti-competitive, and hence if it creates adverse appreciable effect on competition within India, it shall be void. You need not even know what is cartel. Still, you can write this kind of an answer, right? So that easy is Competition Act actually. Same way, now we'll see about other vertical agreements. See, vertical agreements, you have to prove with reasons, only then it becomes, that's why, see, remember the heading, you're able to appreciate the two differences between vertical and here, horizontal agreements are anti-competitive. Vertical agreements may be anti-competitive. Okay, you're able to understand the difference, I guess. Okay. Now, what are types of vertical agreement? So these are tie-in arrangement. So like everywhere I try to give an example. So just try to relate. It will be easy. Tie-in arrangement, when you're getting a new gas connection, they'll be forced to buy a new gas stove also. Correct. So this is example of tie-in arrangement. When you get a new Android phone, it will come bundled with all Google apps like Google Chrome, Google Maps, Gmail, etc. So this is also like a full line forcing. This is also an example of tie-in arrangement. Then exclusive supply or distribution agreement. This is what we discussed about Domino's and KFC. When you go there, they will either give you only one product, like either Coke only or Coke products, and they will be restricting to deal with any other products like Pepsi. So that is called the exclusive supply or exclusive distribution agreement. Then there is a refusal to deal agreement. See, there is this thing like Bata generally Bata don't manufacture shoes. They just only get the shoes manufactured from someone by giving the raw materials. So people who are supplying the raw materials to Bata are prohibited to sell. If they produce excess of raw materials, they will not be allowed to sell to any other party apart from Bata. So this kind of agreement only to give to Bata is called refusal to deal agreement. Okay, so then there is a resale price maintenance agreement. That is if a Maruti car manufacturer fixes the price at which it has to be the minimum price below which you cannot sell the car. Like if they are fixing 5 lakhs is the minimum price before which you cannot sell a car, below which you cannot sell a car. That kind of agreements are called resale price maintenance agreement. If they ask you any of this question, like say resale price maintenance agreement is a vertical agreement. Okay, always remember the same thing what we discussed under there also. Like retail price resale price agreement is a vertical agreement. Okay, vertical agreements are anti-competitive only if it affects the competition. Okay, and if it affects the competition, it shall be void. Simple, right? Vertical, like resale price agreement is a form of vertical agreement. Vertical agreements are anti-competitive if it affects the competition by creating adverse appreciable effect on competition, and hence it will be void. Easy. Okay, so now only we are coming to see what do you mean by adverse appreciable effect on competition. WAE. What do you mean by adverse appreciable effect? So when it comes to anti-competitive agreements, you are checking the two factors. Anti-competitive factors, that is CCI will check when they are conducting an inquiry whether it creates adverse appreciable effect on competition or not by checking this anti-competitive factors and beneficial factors. It will weigh the factors which how much of it are creating anti-competitiveness and how much is actually beneficial. So if it creates barriers for new entrants or drives out existing competitors out of market, like say when Geo entered, like many players like MTS, Tata Docomo were thrown out of market. Okay, same way, like whether there is any foreclosure of competition by hindering entry into the market. Just a second. Yeah. So we have to check that whether this kind of things, like say in foreclosure, you can think of there is only two players in the market for cab aggregators, Ola and Uber. Third player cannot enter. So these are all anti-competitive factors. Beneficial factors or benign factors are like, see, only after Geo came in, we started getting 1 GB data per day. Otherwise, it used to be 1 GB data per month. And promotion of technical and economic development, because we heard of the concept of 4G only after Geo. Now there is 5G also we are talking, and there are fiber technologies also. So advancement in technology. So competition commission will weigh all these factors and see whether it creates a adverse appreciable effect, or if there are more factors on this and less factors on this, more on this, less on this, then it's adverse appreciable effect. Other way around, if there are less of this and more of this, then it does not cause adverse appreciable effect. Simple. So this is how they will actually weigh and come to a conclusion. Okay. So see, if you understand this, like all other pillars are very easy. Okay, because you have to read it together. If they ask you a question on bed rigging, so first we already told bid rigging is a form of horizontal agreement. If horizontal agreement creates adverse appreciable effect on competition, it is void. Clear? Now, whether bid rigging creates adverse appreciable effect or not, for that you have to check how much is the anti-competitive factors and how much is the beneficial factors. Basis which they will decide whether it is a adverse appreciable bid rigging creates a adverse appreciable effect on competition or not. If it creates adverse appreciable effect on competition, then what are the orders which the competition commissions will pass? So for bid rigging, which is horizontal agreement, and if it creates adverse appreciable effect on competition, this is void. So in that case, competition commission can pass cease and desist order. Cease is stop. Desist is don't do in future. So such agreement shall not only be discontinued. Discontinued is ceasing, but shall not be re-entered in future. That is desisting. Clear? So cease and desist order. This is one of the important orders of Competition Commission of India. Cease and desist order. Then they can impose a penalty. So penalty can be 10% or less of the average turnover for last 3 years to parties of the agreement. Okay. Then they can ask them to modify the agreement, some kind of agreements. If there is, they may ask them to modify or pass such other orders as Competition Commission may deem fit. Clear? So these are the orders which they can pass. So the same concept applies to abuse of dominance also. So the same way we'll be dealing that also. So hope this is clear. And actually this is easy, right? If you have any questions, you can ask me till now. I'm assuming it is clear. Just skim through this. Ready? So, see, remember in exams they ask you whether dominance is wide. Remember, dominance is not wide. Only abusing of dominance is wide. Only if you abuse the dominance is wide. Any like any agreement by enterprise abusing the dominant position shall be anti-competitive and hence wide. Right? There are two types of abuse: exploitative. It can be abuse which is exploitative to consumers or exclusionary for competitors. Exclusionary is like Tata Docomo is kicked out of competition. That's what exclusionary, excluded from competition. Okay, exploitative if it is exploiting the consumers, because Airtel used to give 1 GB data, like they used to charge so much for a 1 GB data also, right? That is exploitative. Or if it is exclusionary for competitors, some people are thrown out after entry of Geo, right? So, what do you mean by this dominant position? Okay, so dominant position means the position of strength enjoyed by an enterprise in relevant market in India. See, you would have heard of MTNL because MTNL is not in Tamil Nadu, whereas MTNL is there in Maharashtra, right? So they have actually distinguished MTNL will operate only in Maharashtra. So because of which MTNL enjoys a dominant position in that particular market. So, what do you mean by the relevant market in which they are enjoying this dominant position? So, relevant market can be a geographic market or a product market. Okay, which we'll discuss when we are discussing this differentiate. Before that, just remember, under MRTP, monopoly was wide, but under competition, only the abuse of monopoly is wide. So you can be a monopoly, but once you start abusing, that is, if you do something which is anti-competitive in nature, it becomes wide. Hmm. So, what is this relevant geographic market and relevant product market? See, just try to see the word which is in bold. Products are distinctively homogeneous. That is, rice is more in South India, which is distinguished from wheat in North India, or products which are interchangeable or substitutable. Okay, like say for example, you can buy Colgate. Okay, Colgate is substitutable to Pepsodent. Okay, so these are the relevant product market. So these things is what competition commission will consider when they pass an order. Okay, now we'll see how we have seen various ways of horizontal agreements and vertical agreements. Now, what are the modes in which the abuse of dominance can happen? So, same way, abuse of dominance, if it is anti-competitive nature, it will be wide. So, if they ask you anything on this, it is you have to say unfair like say if they ask you on predatory pricing is a abuse of dominance, which is anti-competitive in nature and hence wide. Okay, so predatory pricing is nothing but like when Geo was introduced, they introduced at such a low cost. And when all the competitors have gone out, like Tata Docomo, MTS, everything gone out, they started increasing the prices. These kind of things are called predatory pricing. Then whether it limits or restricts any kind of scientific or like any kind of a development which is prejudice to the consumers, can be abuse of dominance. uh, Using dominant position in one market. See, Geo is now having a lot of things with Geo phones and Geo Sims. Now, with that dominant position, is trying to enter into a new market called Geo Mart. Okay, they will have a benefit because already it has created a thing in the Sims market. Now they are trying to enter the Geo Mart, and or they're making any denial of market access to small players because they're like MTS same and all not able to sustain. So this kind of things happens. Then also it is a abuse of dominance. Then like sometimes you'll be forced to get something else also. Like when you're taking a broadband connection, a BSNL, you will be forced to subscribe to Amazon Prime. So these kind of things which are totally not connected, but they impose this obligation. So these are all the modes of abuse of dominance. So abuse of dominance, which is anti-competitive and hence void. So now, when it will be anti-competitive. So that is what CCA will determine. CCA will inquire that whether it is anti-competitive or not basis the following factors. Okay, so what is the market share vis-a-vis the competitors? Like Airtel, what is the market share? Jio, what is the market share? Then whether there is a commercial advantage because of this vertical integration, like Maruti owning its own Nexa showrooms. Is there any advantage of having their own showrooms rather than giving it to a separate dealer? Then dependence on consumers on enterprise. So because if you want a 4G connection, you will definitely have to go to Jio or Airtel. So how much is consumers dependent on the particular company? And the monopoly or dominant position, whether there is it creates a monopoly or dominant position, or whether there is a regulatory entry barriers. That is, railways can be done only by government till the time they recently privatized a small portion of it. What are the social obligations, social costs? Like what, how much is the CSR activity done by the companies? So, say for example, this Jamshedpur is called Steel City because of Tata. They have done so much of benefits there to the citizens of Jamshedpur. So because of which there is a economic development of the whole city. So they will consider all these factors. They will weigh all these factors, and if it is beneficial, they will say it is not anti-competitive. If it is not beneficial, they will say it is anti-competitive, and they can same way how we discussed earlier, they can pass the following orders: cease and desist order, penalty. There is very slight difference only. In cease and desist, here they say the abuse of dominant position shall be discontinued and shall not be entered in future. That is, stop and don't do it in future. Like penalty is almost the same for the enterprise abusing the dominant position. Or they can if the enterprise is so big, they can ask to divide the enterprise also, and they can transfer all the assets into like multiple enterprises. Clear? Now coming to the next thing, combinations. The final leg. First, we have seen about prohibition of anti-competitive agreements, and then we have seen about prohibition, the abuse of dominance. Now we are discussing about regulations of combinations. So combinations can be remembered with this: mergers, amalgamations, acquisitions, and takeovers. Right? If it causes are likely to create adverse appreciable effect on competition, then it is prohibited and hence void. Simple. Now, a combination can be the form of acquisition of control, this, that. If it exceeds the thresholds mentioned in the table below, we'll see the table in the next thing. The following things to be done. See, remember, all these steps has to be followed only if it exceeds the thresholds which is given in the table in the next thing. Okay, so we'll see the thresholds of first. Just a second. Okay, so these are the statutory thresholds. Yeah. So whether it at the enterprise level or at the group level. enterprise level or group level. If any of these things happens, that is acquisition. See, this enterprise level means there'll be single acquirer. Group level means there'll be a group of acquirers. Single acquirer doing different goods or group doing dissimilar goods or services. Okay, so this is general acquisition of shares, acquisition of control, and merger or amalgamation. Acquisition of shares, acquisition of control, merger or amalgamation, right? If we have to check where it is happening, where it's happening in India or worldwide also with India. So you can think of like Flipkart. When it is acquired by your Walmart, it was not only impact in India, but there's a worldwide impact also which has happened. Okay, so that's what we have to analyze, and we have to see this based on the assets and turnover. Okay, so how much of like only if you exceed this limits, the thresholds, only then you will be required to comply with the steps which are there under combinations. So just see this last line. So you have to only remember these two figures: 2,000 crores, 2,000 crores is here, and USD 1 billion with 1,000 crore in India. Total USD 1 billion with 1,000 crores in India. If you just remember this, okay, then you have to multiply by 3 towards this side, multiply by 3 towards this side, multiply by 4. Yeah, 2 3s are 6, 1 billion into 3 3 billion, 1,000 into 3 3,000. Same way, 8,000 into 3 25,000, 4 billion into 3 12 billion, 1,000 into 3 3,000. And same way, 2,000 becomes into 4 for 8,000. 1 billion into 4 becomes 4 billion. 3 billion will become into 4 12 billion. Clear? Easy. So what you have to remember is just this. You're here you have to multiply by 3 on the horizontal side and multiply by 4 on the vertical side. And you have to remember only these figures. Easy to remember this statutory thresholds. Yeah. Yeah. So once the statutory thresholds are increased, but there is a de minimis exemption. The de minimis is if it is very small thing. Okay. So if the target enterprise has less than 350 crores of assets or less than 1,000 crores of turnover, then it will be exempt. Similarly, group excising less than 50%, this will be exempt. So this is a de minimis acquisition with very small acquisition. The exemption is given if the target enterprise is falling with lesser than this limits. Okay. Now the steps to be followed. If you fall under this, if you exceed the thresholds, what we have seen, first step, this is you try to remember this section because this is generally called section 6.2 notice. So section 6.2 notice has to be given within 30 days of the board approval or execution of agreement, board approval, merger amalgamation, or execution of agreement for acquisition of control. Within 30 days, you have to give to Competition Commission of India, or Competition Commission itself can suo moto also ask if within 1 year of the combination so entered. So if you don't give this notice, then they can impose you a penalty of 1% of total turnover, okay, or assets, whichever is higher. If you don't give this 6.2 notice, it's called 6.2 notice only. So combination can come into effect only after 210 days of giving 6.2 notice, or after getting orders of Competition Commission of India, whichever is earlier, if it does not create anti-competitive, if it does not create adverse appreciable effect on competition. Okay, this section 6.2 notice is not applicable to public financial institution, foreign institutional investor, bank or venture capital fund which raises funds in normal course of business. They do it, their business itself is to raise funds. So by default, they may cross these triggers. That is the reason why they need not have to give this section 2, section 6.2 notice. Okay. but there is a separate reporting for them which they have to do within 7 days. So remember, combination is only regulated. There is no registration, no prior approval. You have to just submit this notice, 6 to notice, wait for 2 10 days, and see whether any orders is passed. If no order is passed, it's a deemed approval. So now similarly, like how we have seen earlier, inquiry into combination to check whether there is a adverse appreciable effect in competition or not. For that, the following factors may be considered. Like what is the level of competition through imports in the market? Because Sterlite is closed, there's so much of copper import which is happening. Then like extent of barriers to entry into the market, level of combinations, or likelihood to increase in prices, whether Flipkart has increased the prices after being acquired by Walmart. Extent of effective competition likely to sustain in the market. GeoMart has also come in after, even after like giants like Walmart acquiring Flipkart. Also, a new player in India has started called GeoMart. So market share individually and market share as a combination, and there can be a you would have seen like many company owned retail outlets. So whether if they both combine by way of vertical, you remember this horizontal and vertical agreements, right? Same way, like if there is a merger of Maruti and Nexa showrooms, that is what company owned retail outlets. What is the impact which it happens? They will balance like whether benefits outweighs the adverse impact. Then they will pass the orders as listed below. Before that, here there's one other step. like uh, CCI can ask the Director General to do investigation. So Director General, CCI to form a prima facie opinion on combination, then it can ask the Director General to do a investigation also. And if Director General also feels that yes, it creates that, then they can actually start taking actions. The actions can be in the nature of orders. So here also there is a similar thing, but it's little different on combinations. Whether combinations will take effect or not. Okay, combination shall not take effect if it creates adverse appreciable effect on competition and hence void. Okay, or they can ask to modify some clauses in the thing to eliminate the anti-competitive effects. Then it can take effect. Or combination to take effect if any amendments suggested by competition commission is accepted by the party within 30 days. Okay, so what you have to remember here is you are only wait for 210 days. If no order is passed by competition commission within this 210 days of giving this 6 to notice, that is that within 30-day notice, then it is deemed that your combination is approved. So this ends our discussion on competition law. Hope it is clear. See, it's actually very, very, very easy. You have to only remember the four pillars and whether it creates adverse appreciable effect on competition or not. If it creates adverse appreciable effect on competition, then it is void. So you have to remember which category what falls under. You have to always remember like cartel means it falls under horizontal agreement. If they ask you a question on exclusive supply or distribution agreement, you have to remember it falls under vertical agreement. As long as you remember this predatory pricing, you have to remember it falls under abuse of dominance. So you have to only remember this. If you can remember this, then if you remember this table, then you are all done. On competition law. If you have any questions, you can let me know. Tomorrow, same time, we'll discuss on foreign exchange laws, that is FEMA. Any questions? If you like the session, thanks for attending. So, see you there. Thanks, everyone.